Welcome to Simply Legal. I'm your host, Geraldine Warren, longtime Medfield resident and practicing attorney here in Medfield. Each month I present a topic that I hope you find not just informative, but also useful. Today will be no exception. Today the topic will be supplemental needs trusts and trust administration. And I'm very fortunate to have with me today Chris Milne from Milne Law, a law firm here in Medfield that concentrates on trust administration. Welcome, Chris.
Thank you. Thank you for having me.
I've been very fortunate by having referred clients to Chris for trust administration. I was very impressed that his firm has a team approach. So Chris, could you just tell everyone a little bit about yourself and how your team works?
Yeah, my law practice, I guess it's kind of unique. We administer supplemental needs, special needs trusts, and the focus of our practice is all the responsibilities a trust has, but a recognition that the purpose of these trusts, buried within the trust instrument is what I think is, the most important language. It's to enable the trust beneficiary to have the most fulfilling life possible. And so in my firm, we have typical professionals you would expect to see in a trust administration practice. I have a financial advisor who gives me advice as a trustee on how to invest money. There's a CPA who we work with who makes sure we comply with tax law, whether it be issues of fiduciary tax returns for the trust, state and federal, passing through income and assisting beneficiaries and their family. But the most important thing is how you achieve the trust purpose, giving the beneficiary the most fulfilling life possible. And if people are watching this, they may have a family member, whether it's an adult or a child who has special needs. It might be mental illness, severe physical disabilities. And the way I go about that is, in my office I have a social worker, and I have a lot of relationships I've developed over the years using the economy of scale of my practice to get good rates, hourly fees, whatever it is, with special education attorneys, disability advocates, and we really try to work with the family to improve the life of the trust beneficiary. And so that's what my practice is. I got into it in a kind of interesting way. I spent a lot of my career as a trial lawyer. I'm a past president of the Mass Academy of Trial Lawyers. But starting in the late 90s, I always had a great interest and concern when you recover money for people. As trial lawyers, you're telling juries to give you this money, it's going to change their life, and will it really? So, I started in the late 90s administering, a handful of very small trusts. We worked with, we actually had a program then where we worked with students, clinical PhD students at Clark University, who we got in the field, getting children into after school and summer school programs. And what happened for me is it's just grown over the years, where I have, a lot of responsibility for a number of trusts now, but still the core of it is, to make the trust work for the beneficiary. And so that's what my practice is and my approach to being a trustee.
So I think before we go into the actual administration of the trust, I just want to go over with the audience on the different kinds of trusts you can have. There's a third-party supplemental needs trust, and it's, as it sounds like, it's a third party who would create the trust. It can be any third party, but usually it's a parent or a grandparent. And they may want to have an inheritance go through a will into a trust. So this would be a good way to do it. And it can be revocable or irrevocable, but only for the grantor. It cannot be revocable for the disabled individual. Another thing with the third-party trust is that there's no payback provision. It can terminate and then have the assets that are left in the trust go to a third party, like maybe if the individual had issue or children, that it can go to them, or it can go to a charity, as opposed to the other trust I'll be discussing. So I just wanted you to get an idea that there are third-party supplemental needs trusts that are actually created for the benefit of the disabled individual. And then when you're drafting these trusts, you have to be very careful that you seek counsel from an attorney who's used to doing these, because there are provisions that are necessary to be included in them. So if the person is on government benefits, it won't affect their benefits in any way. And then you have the self-settled Trusts, which are, some people know them as the Ober 93 trusts, the D4A trusts. These are self-settled because the assets going into them, as Chris was saying, a lot of times it's from a personal injury case and their assets, and it needs to go into a trust for the disabled individual. It can also be an inheritance where there wasn't a supplemental needs trust. These trusts, while are for the disabled individual and funded with their funds, it is created in Massachusetts by either court permission, a guardian, or a parent. And as I mentioned, there is a payback provision so that when the trust does terminate, the state can go ahead and get back any benefits that were paid if there are assets left in the trust. The only other trust I'm going to just mention, and we're really not going to talk too much about those because the D4A trusts are for any individual under the age of 65. Once they turn 65, the trust can still be in effect, but you cannot fund the trust once they turn 65. There is a D4AC trust, a D4C trust, which is what the pooled trust is, and many people that may have someone in a nursing home would be familiar with those trusts. Those can be created by the disabled individual. Again, it has to be irrevocable. And those are, again, there's a payback if there's any assets left, if after the individual passes, that the state can go ahead and get back any benefits they may have paid to the individual. So I just kind of wanted to mention the two kinds of trusts we're talking about when we talk about supplemental needs or special needs trusts. And now I want to really turn to Chris on the trust administration. And the first part of that, and something I deal with in drafting these trusts, is who do you pick as a trustee?
Yeah, and I want to, and I just want to, echo what Geraldine just said, that if you're doing an estate plan, potentially a very narrow piece of your estate plan is, you may have, a son, a relative who you want to provide for after you're gone, or even during your lifetime. It's really important to get a lawyer who has an expertise in these type of trusts. I administer these trusts, but I still don't attempt to draft them. I'm very familiar with them. The courts are full of case after case where as part of an estate plan, somebody created what they thought was the right kind of trust and it just isn't. So, it's a very specialized area within a very specialized area, and you want to get a lawyer who does that. And I'm sorry, what was the
I was just talking about when you're drafting these trusts, one of the big important things I find is in choosing the trustee, because a lot of times the grantor and the third-party trust, a lot of times they'll name themselves as the trustee of that trust, but then they'll always have to name a successor trustee. So I just wanted to talk to you about what goes into deciding who maybe should be a trustee in like a third-party trust versus a self-settled trust. So if you could just maybe address the choosing a trustee.
I think, the decision that is often there is, do I get an independent professional trustee or a family member? And the real, first criteria is, are they independent? Are they qualified? And, if you read in the literature, books, articles written on this, they all really suggest that families should look strongly at an independent trustee. If you're blessed to have a family member who, wants to be involved in the life of the beneficiary of the trust after the trust is funded, a really good trust has an independent trustee and then has a family member who has the right to accountings under the trust, which includes the right to information and also removal power of the trustee. And by creating a trust in that way, you have a trustee who has a knowledge of the public benefit programs, how to administer, a knowledge of what the best practices are on distribution, so the trust goes for its intended purpose. But you also have a family member who knows the beneficiary, who can educate the trustee. This is what the beneficiary needs. And also, most trustees out there are really good people. They're honest, they're upstanding. But if there's going to be a problem with the trustee, it's great to have a family member, who has read the accountings every year. My office, we give to whoever that person is under the trust duplicate monthly statements. And when somebody calls our office and asks for a distribution, has questions about the trust, we have a form, and we always ask them, do you get your monthly statements? Do you read them? Do you understand them? And I suggest that's a best practice out there for anybody who's going to be the person under a trust who keeps an eye on the trustee. Most of the problems would be prevented. So going back to your question, who do I choose? If you're lucky enough to have a family member who wants to be involved, I'd suggest you put them in an oversight role and get an independent trustee for the trust.
So again, that would take care of being concerned if the professional was maybe doing something with the assets that are questionable. If you had someone overseeing the accounts, then that would take care of that issue. Would you agree with that? Or?
It would take care of that issue, and and just because I do this for a living, I read very carefully whenever I see a situation where a lawyer who's a trustee or professional financial person. And what I always, the question I posit to myself is, if somebody had been educated on how to keep an eye on a trustee, get the actual statements every month, what questions to ask, not fall for all this baloney on promising rates of returns and results in investments, would have that been prevented? And, it would be. It's very rare you see one where it's not building up over time, there aren't red flags about the person. So, I know when I meet with, potential new clients or I'm executing trust, the biggest concern people have is, will the money be safe and what will happen with it? The biggest concern I have with a trustee is, how am I going to get this money in a bank account to make a difference in their life? And that's something you have to do with the family members. But so I think in choosing trustees, first instances of trustees doing that are very rare, but when they do happen, if somebody's educated to keep an eye on the trustee, then the last thing, I put on a seminar about a year and a half ago through the Mass Bar Association.
I actually believe I attended that.
Yeah, and I really, I wanted to delve into the issue of family member trustees versus professional trustees. And I didn't want to ask the question of the faculty, should you have an independent trustee or a family member trustee, because the fact is there are a lot of family members that are a trustee, and to kind of take a position you shouldn't do that doesn't make sense, because people are. So one of the faculty members who's really respected in Massachusetts, I asked her to talk about the subject matter of, if you have a family member trustee, what is your due diligence in advising them how to be trustee? And it was interesting because at the end of this, the faculty member, gave the talk, and she said, what I learned from the seminar is, if possible, don't have a family member, because you really have to know a lot about public benefit programs. You have to know about fiduciary responsibility with investment, overseeing investment advice, filing tax returns and all that. And in general, a good trustee, what they save, because they'll get cheaper financial advice, cheaper tax advice, and know the programs, should pay for what the cost is, which most people, and I think maybe myopically, say, geez, I have to pay that person. And you do. But having said that, if there is a family member trustee, they're taking on a big responsibility. And the other thing is, and I get a lot of trusts like this, it might go to, and I'm thinking of one I got, it went to, the two brothers, and one decided to be a trustee in an estate, and their sister wanted to spend money on everything in the world that they felt she shouldn't. And what happens then is you're putting the brother, out of the role of being a brother and what he can do as a brother,
to a role of fiduciary.
Yeah, and my, I don't like it when people get mad at me, but it is part of, my job description as a trustee. Sometimes people are very angry at me, threaten all kinds of things, and that's just part of, doing your job. I'm certainly respectful of people when I say you can't do this, but sometimes things just either will interfere with the public benefit program, or interfere with the fact that you have a sum of money that has to be there for a very long time for a person, and they just can't afford this.
Now, when you were mentioning the brother and sister, what came to mind is, so who does make that decision if she wants to spend money on something versus the brother who, as the trustee, may not feel that's appropriate? Do you want to talk about decision making with regards to spending the assets in the trust?
Yeah, well, that's really difficult, and every trust really is its own animal, and in that situation, it was the brother, because before, a state lawyer contacted me and I took over as trustee. It was the brother, and his sister was calling him 20 times a day and angry at him and all that. What I think is, a best practice is, before a trust is funded, to have a common understanding between the person who'll be the trustee, the person who's funding the trust, and when appropriate, the trust beneficiary. It's not always appropriate. You might have an adult beneficiary has a significant mental illness where they can't be part of that discussion. But if they can, you'd like them to be. And you decide, you certainly have the public benefit programs and their rules, but I'll give you an example. I had a conversation with a woman yesterday. The trust is being funded through an estate. It'll be $160,000 into the trust. And, I spoke with the trust beneficiary, and we had a very honest conversation about her living situation now can't be sustained in the long run. And she doesn't get any public benefits. But so, before I'm trustee, we had this conversation about her whole budget, and there's a tough decision here. And in that one, I mean, really the bottom line will be, she's of sound mind, she's legally competent, so we got a trust that's gonna last 5 to 8 years if she goes one way, or 15 to 20 years if she goes another way, and we'll have that conversation another time. There are some areas of spending where I did kind of pin her down ahead of time, where I know, geez, that could be sort of a area where there might be too much, and I kind of pinned her down ahead of time so that once the trust is funded, if I say, geez, I don't necessarily say no, I say, if you keep doing this, you're going to run out of money. I try not to say no, but I certainly can. So, it's a real dialogue about what the power of the money is. If you have a really huge trust, you don't have that problem, but there are a lot of trusts that are smaller and they can make a real difference in somebody's life.
And I think that's a really important fine point that you made. With this was a trust you were talking about where there weren't government benefits that you were so much concerned about, but you were more concerned about how long can that funding, it's funded for X amount of money, 160,000.
Right.
How long can that provide benefits for that individual who's not on government benefits? So
Yeah.
that's an important part. Some people think these trusts are just for people on government benefits.
No, because the two sources of trust that I administer are lawsuits, and the courts really want to make sure that money is protected for its intended purpose. And the other source is people who have money that want to provide for family members.
Right.
They very well may want to provide from family members, and either number one, the resources are such that it's in the interest of the beneficiary not to get benefits because the restrictions on the use of the money, or for whatever reason they don't qualify for programs. But these trusts still serve a tremendous purpose in protecting the money. The things they can do are incredible. Just early this morning, I'm exchanging emails on a gentleman who's been in and out of inpatient psychiatric care. They're trying to get him back into the community. And for whatever reason, the programs he's involved with don't pay for somebody to come in and clean the place he's staying at once a week, which is a big deal for this man. So the trust is going to fill in the gap, and we're going to try to get somebody else to cover it eventually. A wheelchair might break down, but you have to wait 5 years and all this. We buy a wheelchair. Dentures for people.
Dentures is another big one. I know.
A bed, a bed that is appropriate for somebody with a severe disability. There's a lot of great things a trust can pay for, or for some people, just food on the table and a place to live.
Now, in some instances with different government benefits, like SSI has different restrictions on what you can pay for versus Mass Health. Do you want to kind of touch on that, like the differences on distributing with those kind of government benefits?
It's very difficult to do things right if somebody is getting public benefits, because there's two pieces. And the first piece is to get the right trust. So I administer 155 trusts. I've dealt with this for 20 years, and I don't even feel comfortable drafting trusts. So again, I just say get a good estate lawyer, but make sure they have a specialty in these types of trusts, elder disability law, because they're different things. So the first piece is you get the right trust, which is what they call not accountable asset for the program. And the most strict one is SSI, which is a program that has a medical benefit and a monthly check for a person who is disabled, who's an adult, who has never worked. And it's a program where the payment they get every month is relatively modest. But if you create the appropriate type of trust, they can continue to get that benefit and have the trust be used for certain things.
That's right.
That program has, and I would call it a fiction, because it is a fiction, that monthly check is enough to pay for housing and food. So when you administer a trust like that, if you use the trust to pay for housing or food, it will decrease the benefit. So
So just to make that clear, you can pay for it, but it's going to decrease the benefit that the person is entitled to.
Right, and you might have somebody.
You might choose to do that.
You might choose to do that, because particularly in the Boston area, rents are so high. So if you get somebody who's getting $750 a month, and they, in their rent, the best they can do on a rent is $1,200 or $1,500 a month, you might make a decision. I might, and I do this on a number of trusts, to pay the rent from the trust. There's not a dollar for dollar offset. It's basically you use a third of the check, but they still get something. They still get the medical. you might do that by necessity, but the big kind of no-no on those programs is you never give cash directly to the beneficiary, which independent of that is probably a good practice, and you pay for things directly to third parties.
Even like with a haircut, isn't that correct?
We have people, we pay once a month for the haircut, we pay the phone bill, we look at every phone bill, the due diligence of a trustee, which is why you may not want to have a family member do this, always look, how many phone numbers are on that bill, is it really just for that person? On the cable bill, a lot of these are smaller trusts where we might be, it might be impacting their quality of life 5 to 8 years, so we have numbers that we think you shouldn't really pay more than that in a cable bill. So, we review all of those bills. Dental work, which is a big thing, it's not covered by any insurance. SSI lets you pay for 1 vacation a year, which is a big deal for somebody, every crisis you can imagine in a person's life, from criminal problems, helping them find a defense lawyer, custody issues, everything that happens in life, you get involved with it as a trustee.
And what about paying for family members to visit the disabled individual?
I don't do that very often. I try to avoid that. I think that the situations in which I've done it are, if
I know the palms are kind of a question.
Well, the time I'm thinking of one where a court was involved, and and it went through a GAL. The thing we do get involved in a lot is, individuals who need PCAs or even nursing help in the home. And, our best practice in that is, I have an employment lawyer who, let's say somebody, says, for Johnny, we need, he really needs 24/7 care.
I just want to let them know, a PCA is a personal care attendant.
Yeah.
Just for, we end up using language that we understand, and then sometimes we realize maybe the audience is going PCA, so I just wanted to just...
And sort of this is something that I've evolved over the years, because, trying to figure out what's the best way to deal with that is you have a parent or a guardian wants to employ somebody in the home to care for somebody and they need it, and they can't get the hours paid for somebody else. So what we do in my office is we start with an employment lawyer. We have them do a background check on the person. We make sure we comply with all laws, workers' comp, and so on. And I get an opinion letter from the employment lawyer that this person's passed a background check. The wage is reasonable, and sometimes we may even enter into a contract with them. The way I do it as trustee, because I'm not there in the home and I can't oversee the person and really say whether they're doing their job or not, is somebody in the home, it's typically a parent, will have to be the employer. And so my due diligence as a trustee in that case is, number one, to make sure the employment relationship is legal, that we comply with tax laws, and that I rely upon the parent or guardian to attest that they've worked these hours. And and that's something that's a great benefit to families, obviously, who have a disabled person, otherwise might even be in a residential situation. And so that's, we probably have, 6 or 8 trusts now where, we're funding the payroll every 2 weeks, relying on the parent or guardian, and have people in the home or helping out.
Now, do you have a payroll company? Do you hire, have
we use
someone?
A payroll
you
company.
Use a payroll
Yeah.
company. Because we do the same thing in elder
Yeah.
law, where someone, they may not be on one of these trusts, but they still need to have a PCA.
Yeah.
And it's really important that people understand that you have to have that. It
Well,
has
you
to be
have to, what a
documented.
lot
You
of
have to-
people do is they try to pay them on a
Under
1099, and they're not,
Yeah.
they're just, they're not an independent contractor, they're an
Right.
employee. The law in Massachusetts is so clear, they're not, and so as a professional trustee, I can't, so I'll have people who, a lot of times want to hire somebody, and that's our immediate due diligence. If they're, short term, and it's, you might do a 1099, but you do that, you make sure you can get employment data, but, they're definitely not independent contractors. I know probably half the people out there who work in that area are paid as independent contractors, but you don't want to do that. You want to comply with the law.
That's right. And Chris, I think the public can understand from listening to you, how much goes into being a trustee. And I thought maybe you want to talk about like payment that the trustee gets and,
Yep.
you know, just cost of administration, those kind of issues that come up sometimes. And that's a lot of times what people ask me too is like, well, if I get an independent or professional trustee, you know, what will I have to pay him or what will it cost for me to administer the trust? So do you want to talk about
Yeah,
that?
I do. The trust itself will say in the trust that the trustee is entitled to a reasonable compensation compared to what other people are paid in the area. So that's a starting point. What I do for every trust is before the trust is executed, and once I understand how much money it is, you know, what the nature of the distributions and work will be, I will, you know, put in writing to somebody, this is how much, you know, my annual cost will be of trustee. There'll be two parts. You know, there's a monthly flat fee based upon the amount of time we expect will be involved in it. And then we do an annual accounting on every trust every year, and there's a charge for that. The additional costs for trust administration are the investment advice. You know, and for me as a trustee, I mean, I'll tell you what it is. In trusts where we're going to have the money long enough that we choose to invest it, the arrangement I have with Morgan Stanley is the trust beneficiaries pay 45 points, which is a little less than 0.5%. It's a very good deal. You know, people, you know, if you've got 200,000 or 300,000 and you're off the street, you pay, you know, 1.5%, so it's less than a third of that. And then the last cost will be if there is enough gross income to the trust will have a requirement to file a state and federal fiduciary tax return. I have an independent CPA, but I negotiate, you know, arm's length with him. And, you know, before the trust is funded, we'll tell you what that'll be, but it'll be somewhere in the range of $375 to $475 a year. You know, the trustee fees on the low end, you know, I have some that are lower, but, you know, $1,500 to $2,000 a year is kind of the low end. You know, if you have a trust that's going to be funded with $100,000, which still might make sense, that's a lot of money. On the other hand, there's a lot of benefit of the money. And then on bigger trusts, there's a lot of responsibility. It could be more, you know. If you go to a bank, a lending institution, they may express trustee fees as a percentage. I don't do that, although in some of the bigger trusts, I'll tell people if they did what it will be so they can compare. You know, so you know, there is a cost to trust administration. In some of the smaller trusts, it's nice to just put the fee on the table because, you know, going back to this conversation I had with a woman yesterday who's the beneficiary of the trust with 160, one thing, you know, I like to say to people is, you know, let's say you have 160 or 100,000. If you have that money in trust for 15 years, figure out how much you're going to pay the trustee and for the cost of trust administration. If you have it in trust for 10 years, you're going to pay less. You do want, you know, the highest percentage of the money
To go to
the beneficiary. So in a smaller trust, that's something you can do. Now, I get a lot of trusts where there's kind of nowhere else for the money to go. You know, it might even be 40 or 50 or 60,000. And in that trust, you know, I really try to, you know, and be upfront, and if it's a court, let them know, you know, this is like 5 years of making somebody's life better, and this is how. But it doesn't make sense to string it out to 10 years, because then instead of this percentage going to administer the trust, this does, and how is that good for the beneficiary? So, and you know, the main thing about fees is, I think from the consumer's point of view, is make sure you get it in writing before the trust is executed, and, you know, make sure you know, check the fee and make sure it's what's agreed to.
Now, when you were talking about your team approach, you mentioned a social worker. Would she get paid from the trust?
The social worker in my office bills her time at $165 an hour. So if she's involved, and that's, you know, in our fee agreement, that's an additional cost.
Okay.
And that's, you know, that's a decision that I make with, you know, whoever's responsible for the trust beneficiary outside of the trust. But my general
For
experience.
instance, I just want to say like a guardian.
A guardian,
Yeah.
yeah, it would be a great person. But my experience in, you know, getting, you know, educational advocates and social workers involved, it's the best investment you can ever make, you know, because their work directly impacts quality of life. You know, when the trust beneficiary gets up in the morning, what kind of services they're getting, what kind of program they're in. For a child, you know, an educational advocate, you know, I have a bunch of trusts where, you know, through the law firm we use for educational advocacy, we've gotten what they call outside of district placements paid for. So you have a child with significant disabilities who's getting exactly what they need in a private school, giving them the best chance at life, because the public school couldn't provide for them everything they need. So those types of investments, there's certainly a cost to them. And my experience also is with parents, when they understand the benefit of that, that's something they don't worry about. But the main thing on any cost is that it be in writing ahead of time, that the person under the trust who gets accountings and information knows what the fee is, and it is completely transparent. It is in the area of trust administration. If you think about it, as a trustee, I have responsibility for somebody else's money, and I have the right and the responsibility to pay myself from their money. So, going back to what I said earlier about having somebody keeping an eye on the trust, there really should be somebody who's a competent adult who, agrees to that arrangement and watches it, and then there won't be any problems.
So I really think in giving kind of like an overview of what we were talking about, I think it's important for everyone to understand what Chris was saying. It's really important that you seek counsel from an attorney who deals with these kind of trusts, and also to really think about it when you go to talk to this attorney, like what you want, who you want to have as your trustee, because as you can tell from what Chris was talking about, it can get very involving with regards to the trust administration. Do you want to have any final words with regards to this?
Yeah, I just say, we talked about a lot of technicalities, and, I can just think of person after person, who I'm trustee for, where sometimes you kind of pinch yourselves because you see, the difference the money has made in their everyday life, in terms of their quality of life. So, it's a very rewarding area to protect somebody else's money, and as a loved one wanted to be there to provide for them. And so it's very complicated to navigate through all this, but what somebody wants to achieve for their loved one can be done with a lot of hard work.
Thank you, Chris, for being our guest today.
Thank you for having me. Appreciate it.
Thank you for tuning in to Simply Legal. And until next time, it is Simply Legal.
Production support provided by Medfield.tv. Access to our community.